Well, thanks to my colleagues for those really interesting remarks. Thank you so much for inviting me, Nan. The Alliance for Justice is the leader in calling attention to the pro-corporate tilt of the courts, and I'm always honored to be part of these discussions. I'm here because of an article I wrote in 2008, Supreme Court Inc., describing the pro-business tilt of the courts. I'd like to briefly respond to some of the more interesting criticisms and challenges that have been raised to that piece since it came out, and then think together with you about ways of resurrecting a neo-progressive movement that would oppose corporate influence not only in the courts but also at the grassroots level. So the Supreme Court Inc. piece started with the statistics and noted that in the 2007 term, the Chamber of Commerce had won 15 out of the 18 cases in which it filed briefs. That was the highest number in its history. As Nan mentioned, the most recent stats for the 2009 term were 13 out of 16. I think the stats are pretty consistent, and indeed a recent article by Adam Liptak in the Times a few months ago updated the cases that I hadn't been able to describe in 2008 and confirmed that these pro-corporate trends continue. The gist of my piece had been not only statistical, but to look at political history. And the argument was that the pro-corporate tilt of the court was not a coincidence and was not entirely partisan. Both Democratic and Republican justices shared a bipartisan suspicion of what they called regulation by litigation, and this was the result of a very canny and very intentional lobbying campaign by the Chamber of Commerce that began in 1971 when Lewis Powell, in his famous memo, called for the creation of a lobbying arm of the Chamber of Commerce that would counter the populist influence of Ralph Nader on the left, which Powell described as a menace to American democracy. And this lobbying movement was incredibly successful. The Chamber of Commerce supported the appointment of Supreme Court justices who would favor business interests over economic populism. And this meant, on the right, favoring justices like John Roberts and Samuel Alito over candidates like Michael Luttig, for example, who were more libertarian, might have been more pro-states' rights, and wouldn't have supported the pro-national preemption doctrine that were so important in business cases. And on the left, the chamber supported enthusiastically the nomination of Justices Breyer and Ginsburg, who, despite their many, many virtues, and I admire both of them tremendously, and I think they're wonderful justices, they cannot be described as economic populists in the role of William O. Douglas, for example, who said, "I'm going to rule against the corporations and in favor of the environment." Breyer taught antitrust law. He was the leader, the academic leader of the so-called Harvard School, which was only a sort of moderate version of the University of Chicago Law and Economics School. Justice Ginsburg taught civil procedure. Both share this suspicion of regulation by litigation, which is why the leading opponent of Justice Breyer at his confirmation hearings was none other than Ralph Nader. So for all these reasons, again, these are wonderful justices, but they are not economic populists, and therefore we shouldn't be surprised when we have so many cases which are not narrowly divided 5-4, but are lopsided, unanimous, or 8-1. 80% in which of the business cases that the Roberts courts decided were decided by majorities of 7-2 or greater. So that is why, broadly, this pro-corporate tilt is bipartisan and is hard to deny. Now, that's the response to the first big criticism of the piece. Some people said, well, the Democrats are voting for it too. That's, you know, you can't see this as some sort of Republican conspiracy. They're just following the law. But that misses the point. It's the support of Democrats and Republicans who are suspicious of economic populism that is leading to the pervasiveness of this orientation. The second big response to the piece was that there actually are a series of ideologically divided 5-4 decisions within the broader subset of business cases. And the Center for Constitutional Accountability, led by Doug Kendall, has tallied them up. And you'll find that in the 5-4 business cases, it's a straight Democratic and Republican split, and Kendall and CAC tally up the most pro-business conservative justices and the most anti-business Democratic justices. So that's offered as another counter story. No, actually, okay, 80% of the cases are unanimous, but in this 20% of the cases, there is a strong ideological split. Here, again, I think there's a obvious explanation. That's in a narrow subset of business cases. There are countervailing issues where the Democratic justices do have strong ideological commitments. And these are cases like employment discrimination, environmental law. There are cases like Ledbetter, which was 5-4. It's understandable that when you can understand the strong gender or race discrimination element in a pro-business case, a general suspicion of regulation by litigation or of class action litigation, all the things that are being raised in Walmart and AT&T might yield to concern about social justice. So that's why my colleagues will be able to predict and vote count better than I, but I wouldn't be surprised if in Walmart and AT&T we see those 5-4 ideological splits where the Republicans are anti-class action and the Democrats are remembering their social justice commitments. So those are the two major counters to the broad claim, which is hard to deny in light of the numbers, that the court is, in fact, pro-business. But there's another wrinkle I'd like to explore with you, which is I think when I wrote that piece, I didn't sufficiently understand the differences among conservatives. And in fact, as I think about it, there have been, since the Powell Memorandum, 3 separate strands of legal conservatism, all of which are represented on the court today. Sometimes they're allies, but sometimes they're in significant tension with each other, and that helps explain some of the counter fissures and pressures in these cases. So the 3 strands are the Libertarian Conservatives, the Tea Party Conservatives, and the pro-business conservatives. And briefly, the Libertarians, I think, would be led by someone like Justice Kennedy. They tend to vote with the Cato Institute, so pro-gay marriage and anti-healthcare reform. And after all, that position, which Kennedy might take next year, you could well imagine him in the same term recognizing a right to gay marriage and striking down health care. That's consistent with a very sweeping notion of personal autonomy that people like Cato have championed. Indeed, Charles Fried in Senate testimony a few weeks ago noted that really the argument against health care is not so much based on the Commerce Clause, it's based on the idea that there's some substantive due process, Lochner-like right not to be forced to buy gym memberships or asparagus or all that other stuff that the Tea Party is telling us about. And that's an autonomy right, which has similarities to the autonomy of self that Kennedy recognized in Lawrence and Texas and, bless you, in the gay rights cases. So it's a coherent vision, but as I think about it, that doesn't always lead to pro-business results. Kennedy voted in favor of the Environmental Protection Agency in the global warming case. So again, when his libertarian sensibilities are not engaged, he is willing occasionally to uphold regulation. Those are the libertarians. Then there are the Tea Party conservatives, and obviously the central Tea Party conservative on the court is Clarence Thomas, who's just you don't need to hiss him in this crowd. We all know how you feel, absolutely. But just think about it. Thomas is interesting. He combines social conservatism, support for prayer in schools, with this dramatic anti-federalism and opposition to any kind of regulation, and this anti-elitism, this class-bashing sensibility that you see in the affirmative action cases. He is the perfect Tea Party justice before there was a Tea Party. It helps explain that sensibility that would lead him both to be very socially conservative in the religion cases and also to want to strike down the entire New Deal regulatory state. However, and this is what makes it interesting, in some of the business cases, Thomas's pro-states' rights sensibility will lead him to vote against federal preemption. And in some of those preemption cases, he's the sole dissenter, or one of the few, where he's more interested in protecting states' rights than he is in broad national ideas of preemption. So it's a complication, it's a wrinkle. Generally, he's with the pro-business people, but he will peel off when states' rights are concerned. And then finally, we have the pro-business conservatives led by Alito and Roberts, who were lawyers for the Chamber of Commerce, who filed briefs for them when they were in private practice. They consistently vote in favor of national doctrines like federal preemption, and they also don't support a really radical rethinking of the Commerce Clause because they support national power. So that's why it was significant that the libertarians were so upset when Justice Scalia in Gonzales and Raich, the medical marijuana case, refused to overturn Wickard and Filburn, that New Deal era case that said that the guy who grew wheat in his backyard for domestic consumption could be regulated under interstate commerce because there'd be some tangential effect on the interstate market. Scalia refused to overturn that, joined by Roberts and Alito. He seems to broadly support national economic regulation. And that's why I'm not going to predict this at all. I'm not confident of this, but I wouldn't be surprised if they did not manage to get 5 votes to strike down healthcare, just because striking down healthcare under the Commerce Clause would be inconsistent with the broad vision of national power that Scalia and the other conservatives embraced in Gonzales and Raich. And when you think about Alito, I know the government is hopeful that Alito will vote with them because that justice, Alito, has voted to strike down fewer federal laws than any other conservative. The Roberts Court has struck down 6 federal laws since 2005, between 2005 and 2009, and Alito voted with the majority in only 2 of those cases. So that might not mean that they won't get 5 votes in healthcare, but it does mean that because of these cross currents, there are often at least majorities and sometimes overwhelming majorities in favor of business interests in these cases. So that's the broad complication, but it's helpful to me to sort of separate all that out. Let me briefly close by asking you whether we could resurrect a progressive legal movement. And Larry Lessig in the Huffington Post has called for the resurrection of a neo-progressive movement that would be centered on opposition to corporate corruption, to campaign finance. Other people like Eliot Spitzer and Arianna Huffington are calling for it. You could think about connections with the Tea Party, which shares a suspicion of TARP, and indeed was founded on opposition to TARP. Could you imagine some sort of bipartisan, neo-progressive, libertarian, anti-corporate move? I think it may be hard. As Bill noted, the Tea Party people have been very opposed to what's going on in Wisconsin. They're more concerned about harming the Democrats than being consistent populists. So they've not been very pro-union, not consistent in that regard. But I think the one lesson that we can take from the Tea Party is the importance of grassroots activism. That was not only a movement from courts. They mobilized people, they got them on the mall, they proposed constitutional amendments, they also filed lawsuits, but they really created a national consensus around economic populism. And I think that if we neo-progressives are to have legal success in the courts, we need first to have political success, need to mobilize, need to make the case for why in these tough economic times a pro-corporate tilt is not advisable. And that's why I think our hero should, or my hero, I'm not going to tell you who yours should be, but mine is very much Louis Brandeis, the patron saint of economic populism, who denounced the curse of bigness, talked about the risks that corporations take with other people's money, was a great defender of civil liberties and also judicial restraint, and he always inspires me with his wonderful words, if we are to transform the future, we must let our minds be bold. Thank you so much. Looking forward to our discussion.
Great panel.